Good afternoon, and welcome to today's webinar, Behind the Pages, Animal Law Insights from Our Newsletter Authors, presented by the ABA TIPS Animal Law Committee. My name is Holly Spainhauer, and I'm an associate editor with the ALC's newsletter, and I will be moderating today's discussion. Thank you all for joining us to hear from the authors of our Fall 2025 newsletter articles. We encourage you to ask questions throughout today's event. You can drop your question in the chat or in the Q&A box at the bottom of your screen, and we'll get to as many questions as we can and follow up individually with anyone whose questions we don't get to. And now I'd like to introduce our first panelist, Vanessa Kranz. Vanessa is a recent graduate of Vermont Law and Graduate School. Currently, she is a staff attorney investigator with the Vermont Human Rights Commission, where she investigates allegations of discrimination in places of public accommodation. She's passionate about human and non-human animal rights. All right, Vanessa, go ahead.
Thanks, Holly. And thank you all for being here today. I really appreciate your time, wanting to learn more about our articles. I want to start by just explaining a little bit of why I chose to write about the topic I chose to write about, which involves, if you haven't read it, grief over companion animals and kind of gaps in the law around burial rituals and around cremation, and I'll get more to that. But this topic is not abstract for me. It's deeply personal. So last year, our cat Apollo was diagnosed with terminal cancer, and like many people who love their companion animals very deeply, I found myself experiencing anticipatory grief before I even knew what that term meant. I was grieving someone who was still alive. I was trying to be present, trying to savor my time with him, while also bracing myself for the loss of him. And what surprised me most about this experience was just how isolated I felt, even though I'm in the animal law world and surrounded by people who deeply care for companion animals. It still was a very isolating experience. And even though Apollo was my family, society does not always recognize that kind of grief as legitimate or worthy of space. And so I initially thought that my paper would focus entirely on companion animal grief. And that's because I was kind of drawn to these questions of why grieving animals just felt different, why it's minimized, and why so many people feel pressure to move on or quickly replace their companion animal. And as I researched, I learned about this concept of disenfranchised grief, which is grief that is not openly acknowledged or socially supported. And so that concept deeply resonated with just what I was experiencing at the time. And as I continued researching, I then stumbled across a series of news articles that kind of shifted the direction of my paper. And these were stories about families who thought that they were honoring their companion animals in death through burial or cremation, only later to discover some really awful truths. Animals being dumped in landfills, ashes returned that were not their companions, cemeteries that promised perpetual care, but they were actually on leased land. And then layered on top of that, the realization that in many states, even if a human desperately wants to be buried with their companion animal, that wish is legally prohibited. And so that kind of intersection between grief, law, and systematic failures is what ultimately shaped my article. And so my paper explores how people grieve companion animals, and why rituals like burial, cremation, and memorialization just matter really so much as that it does with humans as well. Because research shows that many people experience the loss of companion animals comparable to losing a human family member, but with its own unique sorts of challenges. And one of those challenges, and what I experienced was, companion animals can't speak, so those end of life decisions fall solely on the human. And that's really a difficult place to be. I struggled a lot just with decisions about the right time or quality of life. And I think those decisions are really, really unique to having companion animals and dealing with the reality that they all do pass away very quickly. We would love them to be around for much longer. Um, and companion animals provide unconditional love. And so when they die, there's often no socially sanctioned space to mourn them. And rituals help fill this gap. So whether it's burial, cremation, a celebration of life, or even planning to be laid together someday, these are the sorts of practices that people maintain to continue their bond with their companion animal. And they also help process that loss. They help communicate farewell, and they help make meaning out of grief. And so, in that sense, burial and cremation are not just logistical decisions, they're emotionally and psychologically necessities for many grieving families like myself. Um, and so, we know the law treats companion animals as property, but they not only do that in life, they do that in death too. There's no uniform legal framework governing where animals can be buried or how cremation services must operate, or whether humans and animals can be interred together. So instead, we have this really kind of crazy hodgepodge patchwork of state statutes, zoning laws, local ordinances, and private cemetery policies. And that just creates confusion. It creates an inequity and vulnerability during a really, really emotional time for people who are grieving. And so some states I found in my research, luckily, have been evolving. So New York allows human and companion animals to be interred together, and that's just depending on cemetery policy. A lot of religious cemeteries don't allow that, so it depends per cemetery. Louisiana passed a law in 2023 that allows private cemeteries to bury humans and companion animals together. And Virginia permits joint interment, but that's only in a segregated section of the cemetery. And then I also found in Maine, they have a whole family lot cemetery where humans and companion animals can be buried together. So these are just some examples of some progress that we're seeing, but it highlights how limited and inconsistent options remain. Um, and so most companion animals, when we're talking about burial, can only be buried in pet cemeteries. And here I found that the legal gaps are really troubling. Pet cemeteries and crematoriums are very poorly regulated, and grieving families often just have to trust that the businesses are doing what they say they're doing. And this is really difficult to just trust that in kind of like a very emotionally fragile moment in someone's life. And so in my article, unfortunately, there are more than one scandal associated with pet cemeteries and crematoriums. In Michigan, families were told that they had to exhume their animals that were buried in a cemetery because even though that cemetery had operated for decades, the owners never outright owned the land, it was leased. In Florida, a family discovered that their cat's ashes contained glass, metal, and human remains. And then in Pennsylvania, more than 6,500 families were given ashes of unknown animals while their companions' bodies were discarded in landfills. And so what is really striking about what's really striking is that these harms weren't inevitable. They were enabled by a lack of oversight, a lack of transparency, and consumer protection. And so legislatures in these states, there are a number of proposals that are made to regulate this industry, but no states have passed anything, which is really sad because it seems kind of like a no-brainer. What's stopping them? And then meanwhile, families continue to suffer, and I'm sure there are multiple areas across the United States, not just in Michigan, Florida, and Pennsylvania, where these things are happening. So for me, writing this paper became a way to process my anticipatory grief while channeling it into something constructive. And I kind of started this process while Apollo was still alive, and then he passed. And so, this has all helped me process the loss of him. Um, and I realized that the law does not just shape how animals live, but also how they're treated after death and how humans are allowed to mourn them. And I don't believe that everyone grieves in the same way, of course not, or that being buried with your animal is mandatory, should be mandatory. But I think that people deserve meaningful choices and that people deserve protection from being exploited by industry. And I had a number of people contact me after the article and just say, like, I had no idea that this could be a problem. I want to be buried with my companion animals. This is really shocking to me. And so I think it's something that people don't think about because they just assume that their wishes will be fulfilled after they pass. So if they say, I want to be buried with, my companion animals, they just assume that will happen. So folks, I guess, are going to look into it a little bit more. So thank you all so much.
Thank you, Vanessa. That was really informative, and thanks for sharing your personal story. I think this disenfranchised grief for our companion animals is something that so many of us experience personally. But I think before reading your article, I lacked the words to and the terminology to really articulate my frustration over that. And this is such an important topic, both to raise awareness for the public generally, but also attorneys and policy advocates seeking justice both for our past companion animals and for their grieving human companions. So thank you so much. Now we are going to hear from Alyssa Villamagna. Olivia is a second year law student at Chicago Kent College of Law. She is a junior associate of the Chicago Kent Law Review and is passionate about the intersection of innovation and emerging legal questions in animal law. She earned her BS in Human Factors from Embry-Riddle Aeronautical University and her MS in Industrial Engineering from Purdue University. Before law school, she worked in the aerospace industry for 6 years. And this past summer, she worked with Banner Whitcroft, focusing on intellectual property law. Olivia, go ahead.
Thanks, Holly. I have some slides to share with everyone, so I'm going to share those while I get started. Um, okay, hi everyone. My name is Olivia Villamagna, and my article was on animals as authors in the age of AI and reconsidering original intellectual conception. And so I wanted to share first about how I came to talk or think about this topic. And it happened when I met Naruto through my copyright law class that I was sitting in this past fall. Um, in this class, we read the case Naruto versus Slater, which focuses on a case of a wildlife photographer, Slater, who left his camera in the Indonesian jungle, and Naruto, as pictured on the right, found the camera and started to take pictures of the floor, other primates, and then of himself. And PETA brought suit for Naruto against Slater when Slater published these pictures without any kind of obviously permission from Naruto, claiming that Naruto, owned copyright rights in these selfies that he took. And so this court had to answer the question, are animals considered authors under the Copyright Act? Ultimately, the court decided no, that animals were not considered authors, and they provided two reasons. One was because Congress was silent on whether animals could be authors, since it was not included in the Copyright Act, and therefore the congressional silence should be taken as intent to not include animals as authors in the definition. And then they also pointed to the compendium of the U.S. Copyright Office's practice that cites a really important case, Burrow-Giles Lithograph Company, regarding authorship, that says that original intellectual conception is what is required to be considered an author, and therefore the Copyright Office would reject any works that claim for an animal or other non-human to be an author. And so reading this case raised some questions for me, and I really wanted to look into it a little bit more. Before I talk about the application of what I found to animals as authors, I wanted to give a little bit of background on copyright law and authorship in general. And so my paper generally talks about the fact that animals have original intellectual conception, and that also looking at congressional silence through different types of statutory interpretations does not always mean that congressional silence is their true intent. And so I wanted to look at that a little further. So something that we see a lot in copyright law is that when there's new disruptive technologies, it presents a new opportunity to look at what the Copyright Act means and its terms within it. And so just to provide a couple of examples, the picture on the left is of Oscar Wilde, and that was actually the focus of the Borough-Giles case. It asked the question, are photographs copyrightable? And the court there held that photographs are copyrightable, both because even though the camera is technically the one taking the picture, the photographer has the original intellectual conception of the pose, the framing, the lighting, etc. of the picture. And that also, importantly, the court notes that just because Congress was silent on whether photographs were copyrightable material, that didn't necessarily mean that they intended to not reserve copyright rights for photographers. It just meant that cameras were not around when the Copyright Act of that version was published. Another kind of fun example is just the Sony Betamax, which was the first version of DVR. The court had to answer the question, is Sony contributorily infringing owners' copyright rights through selling DVRs? The court held no, and that's kind of evident since we have that type of technology in our homes today. But that just shows that there's a lot of different disruptive technologies that have raised new questions about copyright law. And one that's most relevant for today is AI. And that was shown to me through my copyright law class as well, that courts are really grappling with what does AI mean for copyright law currently. And most relevant is AI an author? And that question was answered in a case in March of 2025. In this case of Thaler, Thaler tried to submit to the Copyright Office that this image, which was created by AI, was copyrightable, and he listed the author as just AI. The Copyright Office rejected this, and then Thaler sued, saying that it was possible for AI to be an author, and the court here actually held that AI could not be an author. However, it provided statutory interpretation reasons that were a little bit broader than what was afforded to Naruto in the Naruto versus Slater case. Here, instead of the court saying that just because AI wasn't explicitly in the Copyright Act, that Congress meant that it shouldn't be, that it didn't intend for AI to be an author, they went a couple steps further and said that we're going to look at every time that the word author is mentioned in the Copyright Act, we're going to see if by inserting the word machine or AI creates a statutory absurdity. And they found that it did. They said that, if we replaced machine or author with the word machine, the act would say things such as a machine's domicile or a machine's child, a machine's life or death. And of course, that doesn't make sense. However, that might not be the case for animals. And this is kind of what first started my thought around maybe using AI's new interpretation and kind of excitement in the court around copyright law to apply back to animals as authors. And so that was a very brief, quick overview of copyright and authorship. However, from that, I want us all to take that authorship is not defined in the Copyright Act, but we know from the Borough-Giles case, from that picture of Oscar Wilde, that authors are considered through original intellectual conception, and that some cases use broad statutory interpretations, such as not always taking congressional silence to mean intent. And then also this idea of like plugging in the word for author for what we're trying to see if is an author not under the Copyright Act, to see if it creates absurdities. And then, of course, looking at all of this in the lens of copyright law is subjective or subject to change, especially around disruptive technology like we have right now with AI. So applying that all to what we know to the Naruto case, I wanted to see or to show everyone that using the Thaler court, which was the AI an author case, using their statutory interpretation method, if we replace the word author with animals, it doesn't really create any kind of absurdities. Animals have children, they have a domicile, they have life and death. Maybe the thing that would raise people's eyebrows is an animal's mens rea. And that actually ties really neatly into the idea of original intellectual conception that we see as required for authorship. And a lot of that can now be proven through scientific research and evidence, that animals do have the capability of original intellectual conception. Recently in 2024, a group of scientists came together to say that we all recognize that animals experience consciousness. That means that they experience complex emotions like grief, joy, and self-awareness. We also know a lot of research dating all the way back to Jane Goodall is that animals use tools, and people are even more now seeing that it's not tool usage versus on based on instinctual motives or copying. Animals are doing this on an individual learning basis. They're also, in the same study, showed that macaques, primates, which is exactly what Naruto was, possesses extensive capabilities for object exploration, which is what Naruto did when picking up the camera and taking multiple different pictures. And that also bonobos play and pretend and exhibit the ability to create a secondary representation, which basically is saying that they have an imagination. So now that we can see that the broader statutory interpretation would allow for animals to be considered authors, and animals also have the capability of original intellectual conception, what does that mean in practice? I think that, of course, maybe something that's on everyone's mind at first with protecting animals through copyright law, authorship is, could animals be exploited through this? And I definitely recognize that concern. And unfortunately, I think that that's something that happens currently. So this picture on the right is from the St. Louis Zoo. And as an enrichment activity, they have a slew of different types of animals, paint pictures, and then they sell them for, and all the money goes back to the Zookeepers Association. Um, and I'm not sure if protecting them under these animals under copyright law would necessarily protect them. If it did, we'd have to potentially do something like they do for children and have a fiduciary um, assert their infringement claims, negotiate their license, and make sure that all of those proceeds are going towards the animal's well-being. But also, there's this concept of works made for hire in copyright law, where maybe in the case of zoo animals, where it's an enrichment activity rather than something that they're doing on maybe freely on their own accord. Maybe this is better suited to protect animals under employment law. Something that I found that was really interesting is that industrial organizational psychologists are looking into what it means to define who is a worker and are animals a worker. And I thought this was a very cool parallel to the question of are animals an author? Um, and I think all of this to say is that even if animal protection of their works don't neatly fit into employment law or copyright law as they exist today, doesn't necessarily mean that that's just because it shouldn't work. Maybe it's just because those systems are kind of inherently flawed into what we consider as property and creativity and consciousness. And so I wanted to leave everyone with this and saying that potentially what we need to do, instead of trying to kind of fit a round peg into a square hole or vice versa, is that it's important to reconsider original intellectual conception. Um, I think that reconsidering what we think of property and consciousness and creativity, especially through the lens of something exciting like AI, where people are already kind of looking into these like existential questions. It's really important to remember that as we recognize that animals have this consciousness and we have more scientific data to back that up, that we're really taking their welfare into consideration. And then the last thing I wanted to say was that tying it back to Naruto versus Slater is that I think it's important to remember that as we try to advance the law to help animals and advance animals' interests and rights and well-being, is that we might find ourselves on the other side of the like adversarial legal system to someone that might support our views, right? So PETA and Slater actually ended up coming out with a joint statement after the case settled saying that both of them are looking to expand legal rights for non-humans, and both of them have the goal that they want to support and continue to respect each other's work to achieve this goal. And so I'll leave everyone with that and these wonderful cute paintings that two different animals did. So thank you.
Thank you so much, Olivia. Definitely a very timely topic given the proliferation of AI and the legal issues that will arise with AI that we may not have even anticipated yet. And it will be interesting to see if some sort of the case law and case decisions that arise out of that may implicate the rights and welfare of animals in some way. So thank you very much. Next, I'm going to introduce Jenny Bass. Jenny received her LLM in animal law and a JD from Vermont Law School. Her first career was as a technician, designer, and production manager in the live entertainment industry. She has several publications and short articles, and Jenny's focus is on animal law, environmental law, and climate change law. She is currently working at the Blake Fulton Quackenbush law firm. Go ahead, Jenny.
A recent update, I am now at Green Fire Law. But thank you so much, Holly. So I'm just going to share my screen real fast. So first off, thank you so much for the ABA for having me. I really appreciate this opportunity and getting to talk about endangered species. My talk is called Giving the Conservation of Biological Diversity Teeth, or my original article, by implementing an invasive species humane framework that balances ecosystem health with animal dignity. And we're going to cover a couple things. The first is what inspired the original paper, and then also the ABA paper, and then moving to rights of nature versus individual animal rights, and then finally implementing the Humane Invasive Species Framework itself, which has three major parts, which is prevention, non-lethal removal, and then finally, last absolute resort, hopefully not lethal removal. Moving first to what actually inspired the paper, I was looking into invasive species issues, and I found that, you know, it feels like everything just went straight to killing the animals or killing the plants, and often in the most horrific ways, using poison that cause internal bleeding and, also pollute the environment. So it felt like there had to be better ways to not only combat invasive species to make ecosystems healthier, but also to actually, have less suffering for animals. So, moving first to what an invasive alien species actually is, and they are animals, plants, or other organisms that are introduced into places outside their natural range, negatively impacting native biodiversity, ecosystem services, or humane well-being, or human well-being. They're also they interfere with local other species with predation, competition, hybridization, spread of disease, ecosystem change, and other effects. This is getting exponentially worse because of climate change, and then also kind of even being able to define what invasive species now is becoming a very iffy topic because, some animals may not have other places to go back to. So are they now invasive? If the temperature is now warmer and their area is too hot to live in, are they even invasive? And then I wanted to create a framework that it could actually be used. I didn't want my work to just be something that was like a nice conversation piece. I wanted it to be able to be implemented in a way that could actually affect the lives of animals in a positive way. And then this kind of was emphasized when it came to the issues of rights of nature versus individual animal rights, which is the conflict kind of comes from often with invasive species, if you have, invasive species going into a new ecosystem causing havoc, the supposed conflict is that removing these species, and the proposed method obviously is lethal, is better for the environment. So then that's the individual rights of that animal to its life, and it's, compared to the actual, improvement to the environment. And environmental rights of nature come from two main places. The first is just tradition, some indigenous peoples' perspectives that, indigenous peoples do not have a single word for biodiversity simply because they don't feel that they are separate from nature, that nature has inherent rights. And the second is environmental law, and this can come from directly giving rights of nature to, say, a river or in the Constitution, for example, or it actually can be derived from including rights from like a person's right to a healthy environment. And that supposedly conflicts with rights of animals, which refers to the idea that animals do not have a moral status or do have a moral status and should be entitled to live lives free of abuse by humans. And this, comes from, what Olivia was talking about, their ability, their sentience, and their, have the right to have their own lives and have their own their own dignity. So, is there actually a conflict? And in my view, there's not, because often what's better for the environment is also better for the animals as well. And when it comes to rights of nature, as Kristen Stilt states, at the most fundamental level, if nature has rights and if nature includes animals, then rights-based claims could be made on behalf of animals using existing rights of nature doctrine and strategy. And this actually has been implemented successfully in a court case internationally. And then there's also the Ojibwe view that it's logical to give rights to plants, animals, and the natural world because we're part of it. So moving to the actual framework, the goal is that it could be taken and put into uh, any legal framework. My original work was working with the Convention on Biological Diversity, but this could even be, local invasive species mitigation. So the first step would be prevention. And then moving on, I kind of combined two steps here. For the sake of time, but the next is, do the animals even need to be removed? A lot of animals or plants actually, either have no effect or they have sometimes a positive effect, like plantains can actually improve soil health. So, that would be wasted a lot of energy to remove something that's having a positive effect on the environment. And then from that, moving to not just non-lethal removal, but humane non-lethal removal. And then the final step would be, if absolute last case scenario, there is lethal removal, making sure that it is done in a humane manner. So prevention. This is cheaper. It's a tenth of the cost, and it's also 10 times more effective. Once an animal or plant is in and it's invasive, it's so much harder to remove it, and it's almost always, it's not a complete task. You have to keep on removing them. You have to keep on working, balancing the ecosystem. But if you prevent them from going in, then it's not only better for the ecosystem, but it's better for the animal because they, aren't having to be removed, and they're staying in their natural habitat. This also results in the least suffering and is the ideal solution. And some of these prevention methods are literally just passing laws and, actually enforcing them. One is Australia. They proposed having to keep your cats indoors or like New Zealand, where all of the bird species, there were no cats, so most of the bird species nest on land. So it's easy for cats to kill them, and it's obliterating their cat population or their bird population. So if we just kept cats indoors, that would, be a much better solution than Australia, which is actually having cat killing competitions and that kind of thing. And then moving to humane methods of removal. So even some of the tools that can be used, like gene editing, there's ways that it's cruel and ways that it can be done in supposedly a non-cruel manner. For example, they have RNA gene editing where they've edited mice so that the new mice can't develop muscles, and apparently, assuming it's very, very painful for the animals. But they also use the mosquitoes where they just prevent them from, being able to have a next generation of mosquitoes. And that's, supposedly a lot less harmful to the individual animal. There's other things like Paul Escobar's hippos, where they're using birth control and like just shooting them from afar, and then they can live a happy and healthy life without, continuing to overpopulate the area. And then there's also physical removal without death. Like there was one country that really needed lynx and another country that was, talking about removing lynx. And it's like, maybe if we just pause and see if when there is an invasive species, is there another area that actually needs these species before we kill them? And then finally going to lethal removal, making sure that if lethal removal does happen, that it's done in a way that is, best for the environment, best for the animals. This is avoiding all poisons. A lot of rat poisons cause major internal bleeding to the rats. And then it goes, and then the rat dies, and then an animal eats it, and then that animal has the same experience, and then it goes into the soil, it goes into the water, and it just causes, environmental degradation throughout. But another way to do that instead would be to rewild, would be to put in apex predators like they did the Tasmanian devil in Australia that are taking out the, invasive cat species without, although that does cause suffering to the individual animal, it is arguably better than, having shooting competitions. And then finally, making sure that providing, if there is lethal removal, that it's done with skilled shooters, that the implementation of it is also humane. So it's done with skilled shooters instead of right now the barred owls. They're trying to let anyone shoot the owls, even though there's an endangered species that looks very close to them. Not only will this cause more suffering to the animals for the lack of skill, but also other animals as well. So thank you so much for listening. If you want to contact me, there's my contact information. And if you want to workshop ideas or get information about how to get your works published, I'm here. Thank you so much.
Thank you so much, Jenny. That was really fascinating and comprehensive. Our final panelist today is Alina Pavlova. Alina is a lawyer from Russia. She began her career in animal law in 2017 by joining the ABA TIPS Animal Law Committee, inspired by its values of animal protection, and participating in the International Animal Law Summits in the US from 2017 to 2019. She is also an expert in human rights, gender issues, and transnational crime. As an international consultant, she worked with UN Women on a human rights project in Tajikistan in 2022, as well as with the UN Development Program and the US State Department on an anti-corruption project in Vietnam in 2024. Alina, we're happy to have you begin.
Thank you. I would like to present my article, Ecocide and Wildlife Crime through the lens of human rights, gender, and corruption. My presentation includes the following sectors: why I chose this topic, the doctrine of ecocide, human rights and gender lens, protecting wildlife is a priority. So, in my article, I continue to explore the intersection between human rights, transnational environmental crime, and ecocide, a topic I began to explore in my first article published in the Summer Bulletin of the American Bar Association TIPS Animal Law Committee in 2024. This article is the result of a more in-depth study of this topic, taking into account additional gender and corruption aspects. In a global context, the concept of interrelationship between human rights, ecocide, transnational environmental crime, gender issues, and corruption is currently developing. I highlight the global spread of wildlife crimes linked to corruption, money laundering, and technological innovations that increase opportunities for illegal wildlife markets. I analyze these growing trends alongside the development of the doctrine of ecocide, an international instrument to combat transnational crime against the environment and wildlife, as well as the impact of environmental degradation on human rights and gender inequality. In a global context, animals, humans, plants, ecosystems, and the environment are interconnected and interdependent. Protecting all of them is a global task and a vital goal. Solutions lie in combating transnational crime against environment, corruption, addressing human rights violations, and gender inequality. In my article, I discuss the evolution of ecocide as a legal concept. In June 2020, an independent expert panel was established which proposed adding the following definition of ecocide to the Rome Statute of the International Criminal Court. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. If the crime of ecocide is added to the Rome Statute, it will become the fifth crime in the list of serious international crimes, and the first crime aimed at protecting the environment rather than just humans or their property. According to Article 5 of the Rome Statute, there are 4 international serious crimes: the crime of genocide, crimes against humanity, war crimes, the crime of aggression. And the crime of ecocide can be the 5th crime in the list of serious international crimes. In my article, I show that the development of the doctrine of ecocide is based on the intersection of several branches of international law: international environmental law, international human rights law, international criminal law, and international wildlife law. The national legislation is currently developing faster than international law, and many countries have already established criminal liability for ecocide. However, it is important to criminalize ecocide at the international level. The concept of ecocide can be extended beyond a purely human-centered approach by recognizing animal ecocide for the purpose of protecting wildlife as such. The development of relevant legislation, such as the Wildlife Crime Convention, may also be a solution for protecting wild animals as beings with their own right to life, since wild animals, unlike other animals, farm animals, pets, and others, are not covered by existing legislation. According to Article 3 of the Universal Declaration of Human Rights, everyone has the right to life, liberty, and the security of person. The United Nations considers environmental degradation to be one of the most serious threats to the realization of fundamental human rights, including the right to life, and reaffirms the importance of gender equality in addressing environmental issues. The climate crisis is not gender neutral. It disproportionately affects women, children, jeopardizing their livelihoods, health, and security. Given the close link between environmental destruction, transnational organized crime, corruption, and gender inequality, establishing a global standard with strict sanctions is a way to end ecocide while protecting flora, fauna, and humans. From 2013 to 2015, I volunteered at the Oso Conservation on the Oso Peninsula in southern western Costa Rica. Most of the peninsula is a wildlife and forest reserve protected by the Oso Conservation, which was established to preserve the southern Pacific coast. I participated in a sea turtle program at the Pira Station to preserve the Pacific coast ecosystem, rainforests, rescue sea turtles and their nests. I discovered the jungle, its nature and wildlife animals. I had lived in the city my whole life, but I fell in love with the jungle and realized that this was the real life for me and the best place on earth. I decided to protect the jungle and wild animals. Conscious of the interlinkages between animals, humans, plants, ecosystems, and the environment, we must protect jungles. This is a priority because if the jungle and its wildlife are destroyed, all other elements will also disappear. The only question is when. Thank you. Thank you.
Thank you so much, Elena. Now that we've heard from all of our panelists, we'd like to open it up to questions from the audience. So feel free to continue asking questions in the Q&A. Otherwise, I will get started. I want to ask a question of all of our attendees. Across these articles, animals and ecosystems are often treated as property, resources, or externalities. In the context of your topic, what would it mean in practical legal terms to recognize them as sentient beings with rights rather than as objects? Does anyone want to begin?
I can.
Thanks, Jenny.
I think for mine, it would just help greatly because I think one of the key issues is, finding a legal way to recognize their animal sentience and then having actual outcomes for that. And with mine, if you implement the framework, this gives several steps where if an animal's sentience and, dignity isn't acknowledged and actually has, positive outcomes for them, you could actually challenge it in court. So, for instance, if an animal is lethally removed before non-lethal options are considered, then we have, or they're planning on, hopefully you get there before the lethal removal, then there are actually ways where, you can prevent the lethal removal.
Helpful. Thanks, Jenny. Does anyone else want to answer?
I would just say I think that that goes exactly to like recognizing this concept of original intellectual conception, right? The idea that they have the capability of coming up with something that is unique, creative, made from something that came from their own idea of whatever they're trying to paint, whether that be abstract or in real life. Being able to recognize that they have these capabilities as something independent, I think, like solidifies even within the current construct of copyright law that they have what we consider the capability of authorship. So,
Thank you. Next, we have a question for Vanessa, and this is from one of our attendees. They were wondering about instances in which a human requests that his or her companion animal be euthanized and interned with them when they die. Did you come across that situation at all in your research?
I didn't. I've heard of that, but I didn't go down that route. Just personally, I think that it would bring up just ethical issues. If there's a healthy animal, if I pass away and my dog who's asleep behind me, if my wish was that he be euthanized to be interred with me, that I think is ethically, if he's a healthy animal, there would be no reason to kill him. And I think you'd be hard pressed to find a vet that would do that, that would euthanize a healthy animal. But I didn't research that. I know that that is I don't want to call it a conundrum, but an issue that's come up because I think people have maybe put that in their wills. My suggestion would be, just to create a trust. There are pet trusts that you can create for when you pass away, to have someone care for your animal and to put money away for them. That would be my recommendation. And then when that animal naturally passes away, hopefully they can be interred with their human.
Thanks, Vanessa. My next question is for Olivia. You argue that the court in Naruto v. Slater adopted an overly narrow reading of the Copyright Act. What would a more scientifically informed and or flexible interpretation of author look like in practice?
yeah, so some background to the case of Burrow Giles the authorship specifically is that the reason why the court found that a photographer could own their photograph, even though it's the camera taking it, is because they put originality, intellectual production, thought, and conception into that work. So you can't just like take a picture of a postcard exactly as you see it and create that exact replication of it and claim authorship over that because it's just an exact replication. However, if you pose Oscar Wilde, like the photographer in that case did, you have this kind of idea of authorship over that picture. And I think that by implementing some of the things that we scientifically understand now about animals, being able to have an imagination, they have the ability to manipulate tools to get their desired result of however they want to use that tool. The two pictures that I showed at the end of my presentation are two different animals in a farm sanctuary in South Africa that learned how to paint kind of on their own accord. The pig showed its own interest in painting, but then the sheep actually learned from the pig. And so it's kind of similar to that idea of like either learning through like individual learning or like mimicking, like that humans do as well through social behavior. I think applying all of these things that we know scientifically about animals' capabilities to create um, really shows that this narrow reading of the Copyright Act is not only intended to be for humans. And nowhere in the Copyright Act does it say human. We've just only interpreted it as human because we have a very, or had a very narrow understanding of the capabilities of animals' intellectual conceptions. So.
Thanks, Olivia. Our next question is for Jenny, and it's from a member of our audience. Jenny, how do existing federal, state, and local environmental review laws apply to large-scale programs regarding invasive species, and how might they be modified to address your concerns?
Oh, interesting. I'm going to be honest with you. Most of my work was on an international scale, so working through Convention on Biological Diversity and that kind of thing. I'm not positive about, I don't want to speak too broadly about the actual implementation right now, but the framework could be used in a way that it could be implemented with current laws. And there are, I mean, some ways, like with NEPA, you have to consider if there's other alternatives. So there are like pieces of it kind of in there, but it'd be nice if it was a little bit more robust and actually considered the animals themselves and put non-lethal in front of lethal.
Thanks, Jenny. For Alina, your article frames environmental destruction and wildlife crime as human rights violations. How does this framing change the way governments and courts should respond to these crimes?
So the right to a safe and healthy environment is one of the absolute human rights. And environmental destruction resulting from wildlife crimes and other illegal activities poses a serious threat to the realization of environmental human rights. As I have already said, given the close link between environmental destruction, transnational wildlife crime, and human rights, the solution may lie in establishing a global standard with strict sanctions and criminalizing ecocide at the international level. In that case, governments would have to adopt appropriate legislation and sanctions, and courts would apply them when considering, cases of wildlife crimes. So, establishing global standard and criminalizing ecocide and animal ecocide as a concept at the international level will enable governments to adopt appropriate legislation at the national level, and the courts would apply this legislation and sanctions when considering cases of wildlife crimes. So we must create international mechanisms in order to require national governments and legislation to apply appropriate legislation and criminal liability for wildlife crime.
Thank you, Alina. I have another question for Vanessa. You describe companion animal loss as a form of disenfranchised grief. In your view, what would meaningful recognition actually look like in practice?
So I've had some time to think about this, and just from my own personal experience, I think that just for folks who are friends or family members to someone who has just lost a companion animal, just talking about that animal and sharing pictures and stories. Like, I remember that one time that Apollo did this, or I thought that was very, very helpful. And it was kind of like a way to honor him, rather than people just saying, like, I'm sorry, you know. I think the non-animal people in my life were a little bit didn't know what to say, didn't talk about it. And so I think just talking about it is just really helpful to the person going through it. And then something that was suggested to me that I didn't do, but I like the idea, was writing like an obituary, or kind of like a notice of death, because a friend of mine said it was just really hard for her to just keep explaining the story, or someone that she hadn't spoke to in, months or weeks, didn't know that her animal had passed, and then she'd have to tell them again. So kind of like writing up a beautiful notice and then sending it to your family and friends to put them on notice that this has happened. So you don't have to keep saying over and over again, like, oh, like he or she passed away. So I think that's like a really great idea, and I think that's really beautiful. And then grief groups. And so I had a really, I mean, I'm in Vermont. Um, there's not a lot of people in Vermont. But I tried finding grief groups that were for animals, companion animals. None existed in person. I could only find them online. But I was seeking that because I just wanted to talk to people who had gone through the same thing. And I think that's really important. It's just like um, that bond that you share with people who have been through what you've been through. And so I think it would be great if there were more of those, maybe in more populated areas. There are, but Vermont did not have any in person.
Thanks so much, Vanessa. I'm going to try my best to get one more question for each person in like the 2 minutes we have left before we close out. So if you could try to keep your answer short, I would appreciate it. But Olivia, you touched about this a little bit in your article and in your presentation, but I was wondering if you could speak just a little bit more on, would recognizing animal authorship protect animals or exploit them?
Yeah, so I think that, like I mentioned, I think this unfortunately already happens. However, as we just know more about animal consciousness and sentience, I think that, dark possibility of conscious experience in an animal, it is irresponsible to ignore that possibility in decisions affecting that animal. So I think that as we learn more scientifically about animals, is our welfare and rights in mind.
Thank you, Olivia. I actually have another question for you, but I think just afterwards, it's from the audience. I'm going to connect you with that person so that you can answer it in an email afterwards. And then finally, I just have one more question for Olivia, or sorry, not Olivia, Elena. How can international law move from symbolic commitments to real accountability for transnational wildlife crime networks?
So in my article, I discuss the question of adopting the Wildlife Crime Convention as an international treaty. which can include requirements for state parties to criminalize relevant wildlife crimes and impose strict and severe sanctions. These sanctions may include not only restoration sanctions, but also more severe sanctions, including imprisonment. So today we have United Nations Convention against transnational organized crime, against corruption, and these conventions include serious crimes and relevant sanctions. The same requirements can be included into the Wildlife Crime Convention or another international instrument which will create criminal liability for wildlife crimes, and this liability will concern not only property or another elements, but also animals as living organisms with their right to life and right to not to suffer from environmental wildlife crimes. So severe sanctions and criminal liability, including severe imprisonment liability. So these may be solutions for combating transnational organized crime against wildlife.
Thank you so much, Alina. Thank you to all of our panelists today. Before we close out, I just wanted to take a moment to highlight the work of the Animal Law Committee. We're a community of passionate attorneys and law students dedicated to advancing the interests of animals across a vast array of legal disciplines. Beyond our standing meeting on the second Friday of every month, we have numerous subcommittees for deep dives into specific topics, ranging from companion animals to animals in agriculture to wildlife, to insects and pollinators, to animals in science and technology. Whether you're looking for mentorship, peer connection, or the chance to shape policy through ABA resolutions, there's a place for you. And as you know from today's webinar, we also publish a quarterly newsletter, which is a fantastic opportunity for you to write about the issues that mean most to you. If you aren't already a member, we'd love to have you. Please feel free to reach out to our Vice Chair of Membership, Rebecca Kreitzer, and I will post her I will post her email in the chat before we leave. Otherwise, I really wanted to thank everyone today for all of their interest and engagement. The panelists were fantastic, wonderful questions. Thank you so much for everyone for your attendance today. Appreciate it.